Today, we're talking about spousal support step downs in California. What's that? You're going to find out. Hi, I'm Laurie Itkin. I'm a divorce financial planner and CDFA working throughout California. My website is theoptionslady.com, Laurie Itkin. I am here with Sarah English Wallace, an attorney mediator with Modern Mediation, and her website is Los Angeles familymediation.com. Sarah, welcome.
Welcome. Thank you.
So glad to have you because we've worked on some divorce cases together, you mediating, me providing some financial analysis and support. And you had a case recently where you proposed to the parties a spousal support step down. Can you explain briefly what that is?
Sure. It's a structure for support where the amount of support steps down at particular times by particular amounts.
Okay, so basically we might see something like for the first 2 years, support maybe 5,000 a month, and then maybe in year 3 and 4, it goes down to 4,000, etc.
Exactly.
Okay, thank you for that. So in this case that you mediated, it was a relatively short-term marriage under 10 years.
Yes.
And the parties had a prenup, which we're seeing a lot more prenups these days.
Mhm.
So why was this spousal support step down a potential solution that you offered the clients?
Well, it made a lot of sense for them because of their ages, especially the age of the supported party and her opportunities for future earnings, and developing her earning capacity over time, and also as her needs for being available for their minor child decreased, she could do more work.
I mean, that sounds like a totally rational, reasonable approach to me. Yet, in the cases I work on, usually it's something like a fixed amount until one of the parties may modify it, or maybe it's a lump sum payout of spousal support. I do a lot of those lump sum calculations, and we'll talk a little more about that. But I mean, if the parties hadn't come to you at Modern Mediation, and they had gone the regular litigation route and a judge was deciding spousal support, would the judge be able to present and order something that you help these parties come to consensus on?
It would have been possible, but the attorneys would have needed to have specific facts to explain why the supported party's needs were going to be less at each step down. And for these parties, as well as other parties where the future is uncertain, which it usually is, it's difficult to establish with the level of detail that you need to, that this party's needs are going to be less by that point. Whether it's 2 years and then what's going to happen 4 years from then. And so you need to have facts for each step. And it's pretty tough to have those facts.
Oh, I would think so, especially if each party had an attorney that was setting forth a brief explaining all these conditions, which is in the future.
Yes, absolutely.
So, we were talking that you, in a lot of your cases, you often propose a step down in support. And I was noting that the cases that I work on, as I just said a couple of minutes ago, I see sort of a couple of default options. The one may be, you know what, you're paying X amount a month, and gee, 8 years from now or 4 years from now or 12 years from now, one of your income changes, up, down, maybe circumstances change. One of you can go back and file for a request for modification of the support order. That to me seems like a real pain in the you-know-what.
Mhm.
Or we basically say, look, I can't deal with this. I don't want to have to be paying support forever. And the other party says, I don't want to have to be relying on support forever. I know it's not really forever. And they ask me, hey, Laurie, just calculate a lump sum buyout of support. But this step down, it just seems like such a great option. You mentioned sometimes that even in long-term marriages over of 10 years, you also may suggest this type of approach. How do you think that's received by your clients?
Depending on the circumstances, it's pretty well received. I do more of these in long-term marriages than I do in short-term marriages. but every case is different. And sometimes it's what's necessary in order to meet the needs of both parties in an agreement. There's uncertainty on both sides, but usually when I suggest a step down, there's a good reason why both the supporting and the supported party feel they have enough confidence in the direction that they're going in to be able to make a commitment to each step, and especially in exchange for something else. I also can make these steps modifiable in the event something happens, if the other party agrees. So that can provide some flexibility in case the situation or the circumstances truly do change.
Sure. So that there is an emergency valve, if you will, if something
Yeah.
drastically changes. Well, I have to tell you, as a financial analyst, and I'm always helping people with their post-divorce budget and their post-divorce investing, to have a calendar to know I'm going to live off of X every month, and then in this year or that year, I'm going to live on X minus Y, and then X minus Z. I can, as a supported spouse, start adjusting my career without being pressured immediately, without being rushed, with getting some time. If I'm a primary caregiver, it can, as the child gets older, I may have more time to devote to working. And I just think this is a brilliant idea. And I'm so glad, Sarah, that you are one of the mediators who uses this tool. I think it's terrific. And that's why we're recording this today, because I wanted people to know about it. So folks, if you want to reach out to Sarah English Wallace, who's a mediator, attorney mediator with Modern Mediation, her website is losangelesfamilymediation.com. I'm Laura Yitkin, a CDFA and divorce financial planner, and you can find me at theoptionslady.com. Thanks for watching today.